Question about the validity of emails and whether they constitute a public meeting actually started back in 2015 when the Carroll County Superior Court in Ossipee issued a decision in the case called Porter versus Sandwich. It's a 47-page decision. It analyzes in great detail emails that went out in that case from a zoning board of adjustment chairman to his members, in which certain direction was given to the Board of Adjustment members, and no reply was made to those emails. Nevertheless, consequences occurred as a result of that direction. This led a person who was aggrieved by the action of the board to bring a case under the right to know law against the town of Sandwich. It resulted in a long period of litigation, depositions, and ultimately a 47-page decision in which the Superior Court felt that even if emails that went to all, in that case, zoning board of adjustment members, even if there was no reply asked for or received, that emailing to all members created an opportunity for contemporaneous response. And thus the judge ruled that there was a right to know law violation. He ordered that attorney's fees be paid to the other side, which actually ran into a couple of $100,000 just for the other side's fees, not even considering the town's fees. He invalidated the actions of the town boards that were involved in the emails, and he also ordered that there be remedial training given to the boards that were involved. This is a consequence that I have, in a proactive way, been trying to avoid for this town. And thus, upon receipt of this decision, I undertook some training sessions with the Board of Adjustment, the Planning Board, this board, the Energy Committee, and the Budget Committee to try to avoid this type of consequence. So now we fast forward to 2016, and it is brought to my attention by the Selectmans representative to the Budget Committee that she has been receiving, along with other Budget Committee members, a number of emails, copied to all of them, that seem to contain a lot of commentary that goes beyond just mere information. Commentary that bashes this board, that talks about what positions should be taken. And as a result of that, I sent an email opinion to all the Budget Committee members, which part of my job is to do, and warned them that they were putting the town in jeopardy and their own decisions in jeopardy under the Porter versus Sandwich case that I've just described. The emails did not stop. They continued in the same fashion as before, and that led this board to ask that I direct me to send to all Budget Committee members a request for their emails. Initially, I only received a few members' worth. That were about 35 emails, and eventually, however, after the new year, in various stages, other members provided me with emails. I started to go through those, and whereas I had about 35 emails before, the number, as we went along, rose to about 127 emails. And I'm still not finished counting. But I want to stop counting, because I have seen that within these emails there are about 50 in which there are opinions expressed from one Budget Committee member sending to others various forms of opinion about matters that were in the Budget Committee's jurisdiction. And even if those emails were not replied to, under the Porter versus Sandwich case, those could very well put the town in jeopardy of liability. And I believe it's part of my job to avoid the town having liability, avoid exposure to attorney's fees, avoid exposure to potential fines, all of which could result. In other words, these emails that express opinions create an unnecessary risk of liability. Now, I'm not here to name names. I don't want to get into the specifics of these various emails, but I do want to say to you that starting in June, there were emails that went out that complained about actions by the town manager before, the Board of Selectmen. It continued into the fall with complaints about you're not moving fast enough and you're in getting the budget to us, you're jeopardizing us, you're not doing your job. It's fine to have opinions, but to express them in emails to other budget committee members that create the opportunity for a reply is a prescription for trouble under the Porter versus Sandwich case. As a matter of fact, there were 3 emails in which there were responses from replies to such opinion emails. One of which has been brought up before about a member saying, I've heard on the street that there's people are complaining about raises that have been given. And then another member replies, it bothers me too. Again, it's fine to have opinions, but to have that discussion on budget committee matters conducted outside of the public in emails is a problem and should be avoided. Now we are through the budget season. There was, by the way, an appeal of the Porter versus Sandwich decision to the New Hampshire Supreme Court. That appeal last week was dropped. That case has become final. Granted, it is one Superior Court decision, but it is the one that I know of that most directly addresses the subject. And anyone who seeks to challenge something that a board in town does, that is informed by emails that go to all budget committee members or other board members, could very well cite this case, and potentially another Superior Court judge is going to find that there's invalid meetings being conducted and liability on the part of the town. That should be avoided. Again, it creates an unnecessary risk. We're through the budget season. Regardless of how the vote comes out on keeping the budget committee or eliminating it, we're going to have another budget committee cycle that goes in next year. And what I think should happen is there should be a training session to, again, inform the budget committee, do not do business by emails. It is fine to get informational emails, say from the secretary, saying to you, here's your agenda, here's your schedule. But to get into this thing about, under the guise of providing information, providing emails that bash the Board of Selectmen or bash other people or bash departments is just not appropriate for discussion via email. Again, it's fine to have those opinions. You can express them in an open meeting in the public where people can hear what you're saying, but to try to influence an outcome with these emails that are outside of the public, again, is in my view not appropriate, and again poses a risk of liability under Porter versus Sandwich. I think we have enough of a sample of these emails for training purposes that we don't need to continue to log all these emails. And I would like, respectfully, the board's permission to stop.
I'll make that motion.
Second. In favor.